Welcome back to the Texas Appellate Law Podcast. I'm Jody Sanders.
And I'm Todd Smith.
And our guest today is someone who I bet a lot of our Texas appellate practitioners will know. It is Christina Crozier, who is now a professor at the University of Houston Law School, but is also of counsel at Haynes Boone. Is that right?
That's right. So my full-time gig is at the University of Houston teaching legal writing, and I'm still of counsel at Haynes Boone. And I've been there for almost 2 decades now, which is probably an anniversary that's familiar to Jody because we were in the same law school class.
That's right. I know.
I thought I sensed some familiarity there that I wasn't privy to, so that's good.
Yeah, we go way back.
We do.
Well, let's, I guess, just kind of talk about, I was going to bring up the fact that we went to law school together, but you've already put that out there. But just kind of tell us about how your career path went. You ended up doing appellate advocacy kind of like me, and neither one of us did a clerkship. So just tell us how you got to the job you got to and where it went from there.
Sure. So I think I kind of slid into appellate law in a way that you probably just can't do anymore. I was a summer associate at Haynes Boone in 2004, and I knew I wanted to do litigation, but I wasn't really sure what. And I had this litigation mentor who had to go on a leave of absence. And so for no apparent reason, they put me with a mentor in the appellate group. I didn't know what that was. And I ended up doing a pro bono amicus brief for Allie Levy, who was one of the matriarchs of our appellate group at the time. And she was known for being a really tough legal writer, really good and really hard on people. And she and I just kind of hit it off. And so I kind of ended up in the appellate group without completely appreciating what an amazing opportunity that was at the time. And it took a couple years to realize, I think, how very, very lucky I was.
So did you start out, when you graduated law school and you went back in, were you doing litigation? Were you doing appellate? Were you kind of doing a mix of both?
I went straight into the appellate practice group. So, right away, it was briefing and, working on dispositive motions. And so I've been camped out there the entire time. So when I finally had this opportunity to do the professor job, they asked, would you be willing to stay for a little bit? And it's been a wonderful thing because we have this long-term relationship. It feels like they're my work family. And I love getting to stay a part of the appellate community, which you guys know is a pretty amazing place to be.
It very much is. And I guess, how does that work? Doing both, kind of doing the academic side as a full-time job, but then also doing of counsel work on the side.
I found I can do things during my breaks because we have a nice long Christmas break and a summer break. We have spring break. So I filed a brief over spring break this year. Last year I went to trial during Christmas break. I've also found there are little things you can carve out in tiny pieces. Like I really like being a judge for people's upcoming oral arguments. I can do that in a tiny piece and still feel like I'm adding value and contributing my experience. So it's worked out well. I feel like everyone's really aware and thoughtful about my teaching time and how there's certain times I just can't help.
How did you find your way into the academia side? Because that's kind of another unique transition to go from practice back into academia later in your career.
Right. So I'd always kind of thought it looked like a cool job. I remember we had a professor at U of H, I think it was John Mixon, who said that being a law professor was a loophole in life. And that kind of stuck with me. Like, that seems like a pretty good gig. And I started watching the legal writing professors because I've always been a big nerd about legal writing and just writing in general. And, my Haynes Boone work I enjoyed so much. I just kind of kept up the back burner. I didn't really want to leave it. But maybe 5 years ago, I started thinking it's kind of now or never if I'm going to do it. And, I kind of slipped into appellate work. It was a lot harder to get my foot in the door in academia. I interviewed at the University of Houston 3 times, 3 years in a row. And each time I got a little further in the process, learned a little more, made more friends, and found some mentors to help me along. And so, I think that was a battle that I really had to fight for to get this spot, and I'm really, really loving it.
So what does the life of a legal writing professor look like? Because I know I took legal writing at U of H, and I know there's kind of a difference between the doctrinal and the legal writing professors, but like, what does your life look like, I guess, day to day? And then what kind of stuff do you do in addition to teaching classes?
Sure. So, you teach generally 2 days a week. I have 2 separate classes, but it's the same class. They're just 2 different groups of people. Fridays are sometimes faculty meetings, and the rest of the time you're really prepping. So if you think about how much time it takes to put together, a 30-minute or an hour-long CLE, it's like that, but twice a week. So it takes a long time, your first couple of years, to put your class content together. And then once you have it, like any CLE you've delivered before, and you realize you can kind of recycle it and do it again and again, subsequent years are kind of like that, where you can keep using your content and it gets easier over time. So I'm entering my third year now, and I think I'm finally getting to that kind of sweet spot where things are going to start getting easier.
I'm thinking back to my first year legal writing class, and back in the day, they taught the old IRAC method. And I thought about, well, if I ever went to teach legal writing, what method would I teach? Because that's really all I know, and I'm sure I've deviated from that a lot over the last almost 30 years. Actually, it is 30 years this year. So is that something that's like still out there in circulation, or are there new methods to teach young law students how to think about legal writing that don't involve that particular structure?
Yeah, I mean, IRAC is still very much alive. I think, for your basic classes, your doctrinal classes, that's really what they push for your exams, where you start with the issue, then the role. The main modification that I think most instructors are following today is CREAC instead of IRAC, and that's start with the conclusion. And as you might imagine, that's a whole lot better than saying the issue is, right, when we're writing a court. So you start with the conclusion, then do your rule. Then if you have further explanation of your rule, explain it, then apply your facts and conclude. So it's IRAC, the sandwich between conclusions, which is really what you're doing when you write for the court. It's what you're doing without really thinking about it.
Yeah, that just every time I think about it, having gone to school that long ago compared to the two of you, or at all anymore, I think about that has to be an outdated approach to things, especially, and we can talk about this in more detail, but, legal writing as a whole and writing generally too has changed fundamentally in the last, 10 years or so.
Mm-hmm.
So I just was wondering whether there's been any adjustment to how the legal writing profs are teaching first-year law students.
Are we referring to AI or something different?
Well, AI, yes, but not specifically. More in line with, you've, I'm sure, heard Robert DuBose's talk about legal writing for the rewired brain, where he talks about how we scan everything in this F pattern. And, everybody teaches now to use headings and liberally to use headings and so forth. So back in when I was coming up, in ancient times, headings were important, but it was just a different approach. And so I just was curious about how, in your time doing this, I know that's been not an extended period of time, but what you've come to learn or appreciate about the differences between, even say when the two of you were in law school, how it's changed as opposed to how things are now.
I mean, I think when Jody and I started more than 20 years ago, there was already a strong movement toward...
It kind of hurts when you keep saying that. You don't have to bring up how many years it's been.
There was already a strong movement toward plain language, right? So I already got to benefit from that even when I was in law school. But I do think, we definitely focus a lot on subject headings. I think that message has been heard in academia. I tell my students you really shouldn't be going more than 2 or 3 pages without a new subject heading. I'm sure everyone might have different thoughts about that, but we definitely do need to break them up. I think, as the Brian Garner, theory that we should footnote all our citations is very dead by this point when we consider the fact that everyone is reading on a screen. The big change that everyone is really struggling with right now is AI. For a couple of reasons. Number one, it really just makes writing instruction hard. I think for the doctrinal courses, like think of common law or property, I could see how that would be really useful for studying or for boiling down concepts you don't understand, even for writing an outline, but it gets in the way of writing instruction, right? Because, when I was in law school, and probably a lot of your listeners, your biggest assignment in a legal writing class was probably a memo or maybe a brief or a motion, and you got to take that home for a long time, like maybe a month, right? Now it's just really pretty easy to plug in your problem, upload it, and see what AI spits out. And it might be good and it might be bad, but either way, it's going to deprive the young lawyer the opportunity to figure out how to do it with their brain, which, as you know, is just critical. So instructors are really having to think a lot about doing things in class instead of take home, or at least, doing both of those things together to make sure that no one just kind of, slides along the surface without actually learning how to do it themselves. So that is definitely been tricky, and I'm still playing around with ways to, quiz people in class and make sure that you can't leave your first year of law school without knowing how to do it yourself.
And that carries over into research too, I guess, because research looks a lot different than it did even 5 years ago. I've been playing around with the Westlaw AI assisted research and co-counsel, and I see a lot of potential there. But how do you approach it from the research perspective, as opposed to the writing perspective?
Still starting them out on old school Lexis and Westlaw, in part because not everyone's going to have access to the fanciest bells and whistles, Westlaw and Lexis, but also because if you played around with it, you probably know sometimes the answers are great and sometimes they're just not great. And you can't know the difference until you know how to do it yourself. You know how to read through the cases and solve yourself and do your own research. And so we still have to start with those basics and then fold it in. Here's an option, edit it and see what's wrong with it, what you could have done better. And try to teach students how to be skeptical readers. And by the way, this isn't just a law student thing, it's a lawyer thing. Just in, hey, I don't know if you've been following the headline, but this past month alone, saw K&L Gates, Lathan Watkins, Butler Snow, really good law firms falling into the hallucination traps, being called out by the court or their opponents. And it's so persuasive. It looks so good on the surface. And I think it's drawing in really excellent, competent attorneys and who just aren't, checking on whether this stuff is accurate. There's something called automation bias, and it's the idea that people defer to machines. It's been around a long time, research on this, long before generative AI. But the idea is we tend to put far too much trust into any kind of machine. So think about like the old cases about people who followed their Google Maps off of a cliff, right? We're kind of doing that again, but with AI, and it's because we're kind of just wired to trust it.
Yeah, I mean, AI is definitely having a big impact, and we've talked about that on the show a lot over the last year or so, primarily. But I just, you've now got law students who are certainly digital natives, and they're used to using the tools that are available to them. Not to say that they're being academically dishonest. It's just the reality that they're living in. And I'm curious, how, as a professor, you take them back to those old school days of, here's how to do it all in the books. And you really don't need to look at the computer when they don't even, I'm sure that just blows their mind to think that we didn't even have access regularly to legal research databases.
Right. And, you've probably seen there's some articles out lately talking about how today's college students are not as good readers as they might have been 5-10 years ago. Some professors are complaining that students have never really read a difficult book in high school. And so then those same students might end up in law school and not just be prepared or accustomed to reading meaty cases. And so there's that challenge too, right? On top of all of the AI. One thing that's important to remind them of, and young lawyers and older lawyers too, is the hallucination problem is really, or can be dealt with by going back to all of the same rules we've had all along, which is don't lie about the law, don't lie about the facts, right? And so I think our existing rules are well equipped to deal with this without having to come up with lots of crazy new court rules, that kind of thing. But I think we're going to have to think about them a lot harder than we ever have before.
Yeah.
Especially those of us who are maybe older and who've grown a little bit complacent about this stuff.
I think that's right. And, looking at the cases where lawyers get in trouble, it's almost always because they stopped a step short. They had the AI brief or whatever, and then they didn't go back and just run those cases through. well, I guess number one, verify that they exist. But usually if you're doing that step where you are checking to see, hey, are these still good law? It would come up that, I can't find this. It's a little weird.
I just about face palmed at what Jody just said.
Todd doesn't ever check cases at the end. He just kind of throws them in his brief and goes.
Well, I mean, that's the thing that blows me away about all these things that have made the news, right? It's like you've got very reputable law firms and lawyers who I guess for whatever reason, they have their own reasons, but AI has been interjected in their workflow without having the proper understanding of how it works or what the risks are. And, I think I was nodding my head along with you, Christina, because I agree 100% that we don't need a whole bunch of new rules to deal with this. The ethics of legal research and writing and candor to the tribunal and all of that are just exactly what they've always been. And you, as the lawyer, are the one responsible for what you say to the court. You're not, you can't just pass it off to ChatGPT or co-counsel or any of those. And so I was struck that pretty recently I was using co-counsel for a project, and you can't rely necessarily on what it says, because I know there was an article recently in the news about a hallucination in co-counsel, and I have experienced, even though I'm a big Westlaw advocate, not anything like what you've read in the news or, that you talk to your students about necessarily, but things that are just not quite accurate. And so there's really just no substitute for pulling the case and looking at it and confirming. It's like way back in the day, we would have our briefs site checked, or kind of like a law review blue booking, right? It's like that sort of level of affirmation about the content, may be required and it may offset some of the efficiency gain in AI assisted research.
I also think just the way we work practically as attorneys on teams, we trust other lawyers on our team, right? So if you've worked with someone for a long time and maybe they're a senior associate and they give you a brief, are you going to check every single site? Really? So we need to really be thinking about where those systems break down. And it's a little scary that you could be on the hook when you've had good reason to trust someone for a long time.
Oh yeah. I mean, if you're the partner in that situation, I mean, you rely on the senior associate to do work that otherwise you would have to do, and to do it, a little bit better leverage situation. So, there's all kinds of ways that I can see that mistakes like that can happen. It's just, we're going to have to reach the point. And I guess we're already seeing it because we see lawyers getting sanctioned for this. At some point, I guess it becomes enough commonly reported in the news where everybody's aware. You can't just blindly rely on what you get through AI, no matter what level of research you're at, whether it's case citations or saying what cases or reporting on what cases say that actually do exist. There's a whole lot of levels of errors that can be made if one's not careful.
What kind of tools are you using teaching AI to your students? Like, do you use particular AI tools to just kind of demonstrate how it works and maybe what's good, bad, or, things to be careful about?
Well, I'll tell you what I did last year and what I want to do in the future. So last year, I just did a lot of experiments myself and showed them the results, like what was my error rate, which was remarkably high, and try to kind of dissuade them that way. I don't completely think that worked. I have my suspicions about students who used it with some bad results. And so next year, I think I want to have them play with it more, or at least, give them an output that I found and have them correct it. There is a risk, and you've probably seen this. Sometimes it does a great job. So there's a risk that if you teach them to use it in class and it does an exceptional job and it doesn't hallucinate, that they end up thinking this is great, right? So there's a little bit of a balance on how do you make sure that they come out understanding that this would be helpful, and it can, right? And it can also be detrimental. I'm definitely still playing around with how I want to do that.
Do you have any, you're in a unique position because you've got still 1 foot in practice and 1 foot in academia, and that's probably not doing justice to either one, because I know you're plenty busy and quite talented at both. It's not like you're playing around or dabbling. You're very serious about it. But do you have any tips for, say, the supervising partners in a situation like that where, let's say you've got a younger associate or mid-level associate who's just discovering the AI tools and doesn't really know, all the risks. What's the responsibility of the senior lawyer in that situation?
Right. And maybe we start by having some really open conversations with our coworkers. Like, if
Mhm.
I'm the partner, I am trusting you to have actually checked every citation. If you're working with someone new, to be a little more skeptical than you would have been in the past until that person has had a chance to prove themselves. I think we all just need greater awareness that it could happen to you. It's sort of like Russian roulette, where, you might have 10, 15 great experiences, and then that one gets you in the
Mhm.
headlines, literally in the national headlines.
And I know law firms are having these conversations internally too, in terms of policies and including policies of don't use any AI, all the way to they're creating their own internal closed systems to adopt the technology, or something in between, like what we've just were chatting about with Westlaw having their own product, and LexisNexis, of course, has their own product if you want to stick to the two largest legal research databases. Um, is that something you've had any experience with in terms of dealing with it through like a law firm policy, since you're also a practicing attorney?
At Haynes Boone, we're just rolling out some new AI. We're trying out Harvey, and I'm being trained on that just next week. So I'm kind of excited about that. I've heard good things about it.
It's
Um,
neat.
yeah, yeah. Um, I've been playing with co-counsel and Lexis's Protégé for a while now. But yeah, I think maybe I'm most enthusiastic about Harvey. I found Protégé to be lackluster, and they said it doesn't hallucinate, but it would use real cases, but then say things that were false about those real cases, which was concerning and a very easy way to fall into a trap. So same thing, kind of eyes wide open. I'm excited to play around with the next big thing. I do think it's going to get better and better, but I will note that back in February, a large personal injury firm, Morgan and Morgan, they had one of
Mhm.
these AI hallucination problems with what they said was an internal AI system. So, yeah.
Meaning that it was plugged into bona fide research that had been and then misconstrued what was stated in that research
I'm not
and put
sure
it into a
exactly.
product?
I'm not sure. I know that lots of large law firms are playing around with the idea of making their own internal AI system. So, what exactly theirs look like, I don't know.
Gosh.
Yeah, scary stuff.
Every time I think we're moving closer to reliability and I don't know if you call it a solution, I hear stories like that and it makes me think we're still in the Wild West on this.
And I'm no technology expert, so I don't know the answer, but there are experts who say that we're never going to become hallucination free just because of the way that these models are set up. They're set up to
Mhm.
guess, and that's just foundational, and it's not going to
Yeah.
change. So I don't know if that's true or not.
Well, I guess we'll still continue to see legal ethics training on the ethical use of AI for the foreseeable future.
I'm sure.
I guess from an appellate lawyer standpoint, I mean, what are kind of the things that you're seeing AI can or can't do, I guess, for appellate lawyers?
You know, it's great at summarizing, right? I think that's
Yeah.
perhaps at this time its highest and best use. I've heard some good things about Harvey about uploading a record and
Mhm.
asking it to spit out a statement of facts. I think that could be a good use as long as you're checking everything, right? I feel like the research is still pretty rough and unpredictable. So I know what I would love AI to do is, have me tell AI my legal question, please research this and apply these facts and spit out an answer. That's what it's still doing really unreliably. I know a lot
Mhm.
of folks are having good luck with oral argument questions. Here are the
Uh-huh.
briefs, draft me some questions. It's good at looking at briefing and, finding holes in arguments, things like that. But the thing that I most want it to do, which is write my argument for me, it doesn't do well. And maybe that's good for job security for all of us.
Exactly.
Yeah. Here. I'm not feeling too worried right now, although I do think we're all smart to be mindful of it and see what's coming, because there will be changes. And I think, in the next 5 years, there's going to be even more marked change, and we just all have to kind of ride along and do the best we can. But I think this also ties into me with the ethical duty of competence, of technological competence,
Absolutely.
because we were told that before AI ever came into the picture. There's a lot of people that are drawing analogies to the days when cloud computing first broke, and we were asking ourselves, oh, should we be storing data in the cloud versus storing it on our hard drive? And eventually everybody came around that it was okay to store data in the cloud. You have reasonable security protocols. It's just as secure as bank transfers, for example. But that was not that long ago, it doesn't seem like. And boy, we're in just a whole different world now. It just emphasizes to me the need for just ongoing ethical training, and to the point where the minimum required ethics CLE just isn't going to be enough. If that's all a lawyer wants to do, that's not going to be enough to keep you ethical or compliant when it comes to this stuff. You really, I think, have to be more proactive, or else it's like I read over and over again, that the lawyers who use these tools are going to outpace the lawyers who don't. And it's the ones who don't who are going to be eliminated just because they're not going to be competitive in the marketplace. So I sleep pretty well at night right now because just like you all, I see so many problems with it that it's definitely not going to replace me. But boy, do I want to send my son to law school? I don't know.
But did you know before you before?
No. And this is a much longer conversation. Ultimately it's not my decision. So I just have to leave it at that.
That's right.
I think it's a great job. I feel like our law students sometimes need to hear, like, being a lawyer is actually pretty great. So I'll champion that cause.
I'm glad to hear you say that, actually, and not just for personal reasons, because, I also hear a lot about how, why would you want to go to law school these days? Because the AI is coming for your job. And, you're around first-year law students all the time. And so you get to see their outlook. And I would think that would be kind of a neat experience, because I've not had that. I'm a little jealous of that, as a matter of fact, because I hope that they're eager to join the profession if they see the prospect of it.
I think they are, but I do think they hear a lot of messages. I think we lawyers sometimes, someone says, I'm going to law school, and lawyers feel very eager to say, oof, that's rough. It's a tough job. And it can be a tough job. We know that. But it can also be a really great job. And you're surrounded by really smart people, and you're always getting to do new challenging things. There's a lot of flexibility in the law that you might not get in a typical 9-to-5 job. Right. On the whole, I love being a lawyer, and I hope we can spread that message to our students and our young lawyers too.
Right. And it's a tremendous vehicle to help people, which is something that gets lost in the discussion a lot of times.
Right.
100% true.
I do want to kind of circle back to just legal writing more generally. It's been a while since Todd or I have had a legal writing class, but I mean, what are some things that practitioners even well into their career maybe should think about in terms of legal writing? Are there kind of some tips and tricks that even more seasoned lawyers could use to make their writing better even now?
Yeah. When I started, some people said, I don't think you can really teach writing style. It's kind of innate or not, or it's very difficult to teach. But I do think that there are certain hacks that we can kind of follow, little tips that can kind of force your writing to be better if you just follow some basic rules. And I do feel like I've seen it work. So here are a couple. First one is the lunch test is don't use fancy words that you wouldn't use with a friend at lunch. So, no heretofore, for example, and no utilize either, because none of us are saying utilize at lunch, right? I'll make an exception for therefore and accordingly and thus, but that's about it. So if everyone can take out the fancy words from their language, we would all do better, law students and seasoned professionals alike. Next thing, there are a few little length rules that if you follow, I promise your writing will be better. Sentence length, no sentence should be longer than 3 lines. That's silly. If it's more than 3 lines, that means you are probably combining multiple thoughts in one sentence, or you haven't taken the time to focus on word economy and saying the same thing in fewer words. Paragraph length, same vein. No paragraph should be longer than 2/3 of a page. It's awful to read, and it shows that you're just dumping thoughts in a page without actually grouping your thoughts. So if you get in the habit of making your paragraphs maybe half a page or less, you're going to group your thoughts better. And I know these are simple. This is like preaching to the choir here. But for anyone listening who's trying to start out or up their game, this is just foundational stuff that really works. Next little hack is subject headings. We were just talking about subject headings. Absolutely critical to organizing your thoughts. So if you want a way to force yourself into writing in a more organized way, subject headings will get you there. Of course, they should be a complete sentence, not a little phrase. And I strongly believe they should be 2 lines or less. And I've been told when I was starting out that you can always shove your thought into 2 lines or less. I think it's true. When you're reading a table of contents without even thinking, you can soak that up in 2 lines or less in a way that once we get onto the 3rd or 4th line in a heading, I can't just glance at that and see what your argument is, but I can if it's 2 lines or less. Okay, so that's hack number 2. Number 3, ing verbs. Whenever I started, I had a student say, I had a professor who told me I needed to stop using ing verbs. And I was like, huh? I'd never thought about ing verbs. There's nothing per se wrong with them. When I have students who've shortened their content, saying more with less words, and they're still having sentences that are really confusing, I can almost guarantee it's because their sentences are just littered with ing verbs. And I cannot tell you why. I've tried to research it and try to figure it out, but it's a thing. So I'm going to give you an example. Okay, this is from an assignment. And the sentence said, their being discontinuous does not matter. And it's like, being what? Right? And we can just fix it by saying it does not matter that their cohabitation was discontinuous, right? Or another one that I saw, introducing themselves occasionally as husband and wife does not meet this standard. And so introducing is kind of like a strange way to start that sentence, right? And we can just flip it and say occasional introductions as husband and wife do not meet the standard, right? So if you are finding that your writing is still kind of like confusing and bumpy, on every single ing verb and see if you can simplify your sentence. Last little hack is topic sentences. We all know this, right? But they are kind of the difference between a decent writer and an excellent writer. We were just talking about IRAC earlier. So your issue, rule, apply your facts, conclude. You absolutely must have them in that A when you start applying your facts, right? Because otherwise you're just dumping facts on a page and not guiding your reader about what to do with them. I think a lot of writers, and I'm not just talking about law students, I'm talking about seasoned writers, will talk about the rule and then just start dumping facts and then maybe conclude at the end of the paragraph about here's what you should think about these facts. So, we need to have good topic sentences. It also goes into, your background, right? If you have good topic sentences in your background, your facts going to be really well grouped together. If you have a lengthy rules section and you're using nice topic sentences, you can also know that you're organizing yourself well. And this is a Brian Garner little trick, but if you read the first sentence of every single paragraph of your document and it makes sense, then you're using topic sentences effectively. And if it doesn't, then you're not. And you need to go back and insert those topic sentences. So those are kind of my 4 little hacks. And I promise if you do them and you're not doing them yet, it will make a huge, huge difference.
I like it. Those are easy ones to kind of incorporate without a whole lot of work.
Yeah. So my question then is, okay, what if I have a string cite in my paragraph? Does that word count? Does that count against my paragraph length?
if you're going over 2/3 of a page, I think you're going too far. I'd find a way or footnote that giant string cite. I feel like I have an average attention span and I just can't. I can't hang in there on a paragraph that goes longer than that.
Yeah, I get that.
Any tips on including, not including, or how to write good parentheticals in case citations?
Yeah, I have thoughts. I'm a fan of the old school. This is one of those times when the ing verb is great, right? You start with your ing verb. We're not a robot, so we don't cut out, A's and these and that's, right? So we use the sentence like we would, when you're writing. We just happen to be starting in the middle of the sentence, but we're not chopping out words and abbreviating. And then I think also getting right to the heart of why that case is relevant. I think when I see parentheticals that are just unhelpful, it's because they're putting in way too much information or information that just doesn't really zero in on why that case is helpful. So I love parentheticals, but I don't think they're an excuse for setting or a substitute for setting forth the rule first, right? They're not a
Yeah.
great substitute for that R in your IRAC if we're going back to law school.
I guess we could also mention the idea that briefs should be brief. You probably don't, in your teaching, you probably don't see student written works that are 15,000 words, the word count length for most briefs in our world in state court appeals. So just tell me how you approach that with your students in terms of how long is long enough versus too long.
Right. My students know that I love short, but I think it's tricky because there's a difference between short and substantive and short and superficial, right? And so lots of substance in as few words as possible. I think most writing professors are getting toward the word limits that we're accustomed to in court. And so I don't give them a minimum, but they do have a maximum. And as you guys know, having that maximum can force you to write a little better and more succinctly. And so I think the maximum is useful, but every once in a while I will have a student who's just confused about my love of short paragraphs and documents and think that means superficial, which of course it does not, right? So there's definitely a balance.
Yeah. And of course, we also have to blame Texas's rules a little bit, because if you have a summary judgment with no ground on it, sometimes you just have to address every ground, even if you would rather not.
That's a good point.
Yeah, they can get unwieldy.
One other thing I want to make sure we cover is a topic that is near and dear to both Todd's heart and my heart, and it is that you are the editor-in-chief of the rebooted Appellate Advocate. Let's talk about that.
Definitely. So those of you who've been around for a while and been following the Appellate Advocate, you might know that we've been a little dormant for a while. And so we've tried to reboot starting this year in 2025. And we're going to be publishing 3 times a year. Our issue in January is Best of Advanced Civil Appellate, which I know many of you go to. And then in May and August, we'll have fresh issues with brand new articles. Some of those are updates, and then some of those are fresh articles on hot topics. So, for example, last month we had an article on 15th Court of Appeals jurisdiction. We also had an article on reasons for denying permissive appeals. And so I think we've got some really interesting content out. And if anyone is listening and they want to contribute and be an author, please reach out to me, because we're always looking for interesting articles from appellate practitioners. One thing that's a little tricky is trying to communicate what an appellate article is, right? So I've been trying to say, about articles about appellate courts, about civil or appellate procedure, and then anything else under that appellate umbrella, like error preservation or jury charges or dispositive motions. So, as an appellate lawyer, you kind of know it when you see it, but it's a little bit hard to do your elevator pitch as an appellate lawyer, as you already know, just from trying to explain your job to people.
Or our podcast, for that matter.
Right.
Yep. And in fact, I am going to submit an article to you for the next one.
That's right. I'm looking forward to it. And I appreciate it. It sounds like, to do a little teaser, Jody's going to do an article on Horton, right? So I think...
Oh, yeah. Your favorite topic.
That's right.
Yeah. After your little preview, I think you and I have similar viewpoints about Horton. So I'm looking forward to reading it.
So you'll have to read the Appellate Advocate to find out what those are.
That's right.
Oh, I think some of us know already, but that's okay. I generally agree with you. No, I think that's great. I mean, I was editor moons and moons ago, and it was a lot of fun to do. But we were, at the time, I think we were publishing 4 episodes. 4 episodes. I'm thinking podcast. Scratch that. Edit. At the time, we were publishing 4 times a year, and it was sometimes difficult to get the content and then to package it all up and get it out. And then this was the very end of the actual print, when it was not digital at all. So it was a job. So I certainly respect you taking that on. And it sounds like it's off to a really good launch. I did see the new issue just came out, and it's got some great looking articles in it. I look forward to reading those.
Yeah, I'm really excited about it. For me, it kind of sits at this intersection between the 2 things that I'm doing. It's, part appellate, almost a little bit academic. And, I think in the articles, we're trying to kind of strike that balance between maybe somewhere between a CLE article and a journal. I mean, so maybe the depth of a journal, but the practicality of a CLE. So I think we can kind of occupy a unique space that's useful for appellate lawyers. So I'm definitely excited to be a part of it.
Well, Jody, we can edit this out, but are we ready for tip or war story?
Yeah, I think we can probably wrap up. Christina, is there anything we
Okay.
haven't covered that you wanted to talk about?
I think we covered the big things. I can exit with a tip. Okay.
Sure. Well, we don't even have to give you the softball then. You can just go right ahead and give your tip.
All right. So this is a Lynn Liberato special. So Lynn has been one of the matriarchs of our appellate group in Houston for a long time, and she gives very good free advice. And this is a piece she gives to young lawyers, and I want to make sure we keep passing it along to people. And it is, to get a good mentor, you must be a good protege, because I think young lawyers always want a mentor, right? They want someone to have their back and shepherd them through law practice, but they don't always realize they need to give back. It's supposed to be a two-way relationship. And if you want a mentor relationship that isn't just like the person assigned at your law firm, which usually doesn't tend to be very meaningful, you actually have to think about how you can create a two-way mentorship relationship. So I think young lawyers often think, well, I have nothing to offer, I have nothing to give, and you really do. So you can help someone write an article. If they're giving a speech, you can show up and sit in the front row and nod your head and be a good audience member, and then tell that mentor you did great, because everyone loves to hear that they did great, however seasoned you are. If someone has a table at a legal function and they need to fill it, raise your hand and show up. If someone has a TRO at 5:00 on a Friday, be that person who enthusiastically fakes being happy about it and show up over the weekend, right? Those are the things that will make a mentor want to come back to you. And then you have a two-way relationship that will stick. And, those are the people who will stand up for you, right? So that's my Lynn Liberato rule.
I appreciate it. I think that's a great one. Be the Dwight Schrute to the Michael Scott.
Yeah. It is a really great one, and something that we need to be reminded of. Not only is the advice to the younger lawyer looking for a mentor, but those of us that have been around a while need to just be reminded that they are looking for mentors, because this is not an easy profession. Even it is a great profession, as we have talked about, but being an example to the younger lawyers, showing how it's done and how you can have a good career in this profession and not fall ill to some of the bad things that can happen, or even if you do, that you've made it through.
That's right.
That's, having those kinds of sort of intergenerational relationships are just extremely important. So thanks for offering up that tip.
Gladly.
Well, we do appreciate your time, Christina. Thanks so much for being with us. And we look forward to putting this out in the world. And I always learn something whenever we have guests on the show, but especially the legal writing profs that we've had on. So this is no different. I've learned a few things that maybe I hadn't thought much about before. So we really appreciate you giving us the time and sharing with us.
I'm so glad to be a part of this. Happy 5-year anniversary. I think you're doing great things.
Thank you. Thank you.
Thanks so much.